The rights and obligation of the unit owners. There are 7 rights of the unit owner. First, absolute ownership of unit. Second, co-ownership of land and ownership of common areas. Third, exclusive easement of the area encompassed by his unit. Fourth, non-exclusive easement to the common areas. Fifth, repair, paint, redecorate the interior surfaces of his unit. Sixth, sell, lease or mortgage his unit. And lastly, vote in meetings of condominium corporation. There are also 7 obligations of the unit owner. First, pay the realty tax on his unit. Second, share in realty tax on common areas and land. Third, pay insurance of his unit. Fourth, share the insurance of the common areas. Fifth, comply with use restriction. Sixth, pay condominium dues and assessments. And lastly, give rights of first refusal if so required by the master deed. Why a condominium corporation? First is necessity for creation. The organization of a condominium corporation is optional if no unit will be sold to foreigners. The corporation is mandatory if some units not exceed 40% will be sold to foreigners. In such case, title to the land shall be transferred to the corporation to comply with the constitutional mandate that corporations may acquire real estate provided that at least 60% of the capital or membership is Filipino. Second is the purposes of corporation. The purpose of the corporation is to hold title to the land and act as the management body of a corporation. Third is the conflicts with master deed. In case of conflict between the provision of the article of incorporation of the condominium corporation and the master deed, the latter shall prevail based on the following reason. First, it is the master deed which gives birth to the condominium project. Second, the Condominium Act provides that the articles of incorporation of the condominium corporation shall not conflict with the master deed. Fourth reason is that terms of corporation. The life of the condominium corporation shall be coterminous with the existence of the condominium project. Fifth is effects of voluntary dissolution. The corporation shall be deemed to hold a power of attorney from all stockholders or members to sell their separate interest in the project. Second is liquidation of the corporation shall be affected by the sale of the entire project subject to the right of the corporation and individual condominium creditors. And the last reason is the effects of involuntary dissolution. The common areas held by the corporation shall be transferred through indiviso and incorporation to their interests to the members of stockholders. The transfer shall be deemed full liquidation of the interests of the members or stockholders in the corporation. Pertinent provisions of Condominium Act, Republic Act 4726 as amended. Under with the Section 4, the enabling or master deed may be amended or revoked upon the registration of an instrument executed by a single majority of a registered owners of the property, provided that in a condominium project exclusively for either residential or commercial use. Simple majority shall be on a per unit of ownership basis, and that in the case of mixed use, simple majority shall be on a floor area of ownership basis. Provided further that prior notifications to all registered owners are done, and provided finally that any amendments or revocation already decided by a simple majority of all registered owners shall be submitted to the Housing and Land Use Regulatory Board and the city or municipal engineer for approval before it can be registered. Until registration of a revocation, the provision of this act shall continue to apply to such property. Section 4 as amendment by Republic Act No. 7899, approved on February 23, 1995. Under with the Section 5, any transfer or conveyance of a unit or an apartment, office, or store or other space therein shall include the transfer of conveyance of the undivided interest in the common areas or, in a proper case, the membership or shareholdings in the condominium corporation. Provided, however, that where the common areas in the condominium project are held by the owners of separate units as co-owners thereof, in a condominium unit therein shall be conveyed or transferred to person other than the Filipino citizens or corporation, at least 60% of the capital stocks of which belong to Filipino citizens, except in cases of hereditary succession. Where the common areas in a condominium project are held by a corporation, no transfer or conveyance of a unit shall be valid if the concomitant transfer of the apportionment membership or stockholding in the corporation will cause the alien interest in such corporation to exceed the limits imposed by existing laws. Under with the Section 8, where several persons own condominiums in a condominium project, an action may be brought by one or more such person for partition thereof by sale of the entire project, as if the owners of all condominium in such project were co-owners of the entire project in the same proportion as their interest of the common areas, provided, however, that a partition shall be made only upon a showing. First, that 3 years after damage or destruction of the project which renders the materials part thereof unfit for its use prior thereto, the project has been rebuilt or repaired substantially to its state prior to its damage or destruction, or that damage or destruction to the project has rendered one half or more of the units therein attainable, and the condominium owners holding in aggregate more than 30% interest in the common areas are opposed to repair or restoration of the project, or that the project has been in existence in excess of 50 years, that it is obsolete or uneconomical, and that condominium owners holding in aggregate more than 50% interest in the common areas are opposed to repair or restoration or remodeling or modernizing of the project, or that the project or a material part thereof has been condemned or expropriate, and that the project is no longer viable, or that the condominium owners holding in aggregate more than 70% interest in the common areas are opposed to the continuation of the condominium regime after expropriation or condemnation of a material proportion thereof, or that the conditions for such partition by sale set forth in the Declaration of Restrictions, duly registered in accordance with the terms of this Act, has been met. Section 10. Whenever the common areas in a condominium project are held by a condominium corporation, such corporation shall constitute the management body of the project. The corporate purposes of such corporation shall be limited to the holding of the common areas, either in ownership or any other interest in real property recognized by law, to the management of the project and to such other purposes as may be necessary, incidental, or convenient to the accomplishment of said purposes. The articles of incorporation of bylaws of the corporation shall not contain any provision contrary to or inconsistent with the provision of this Act, the enabling or master deed, or the declaration of restriction of the project. Membership in a condominium corporation, regardless of whether it is a stock or non-stock corporation, shall not be transferable separately from the condominium unit of which it is an apportionitance. When a member or a stockholder ceases to own a unit in a project in which the condominium corporation owns or holds the common areas, he shall automatically cease to be a member or stockholder of the condominium corporation. Under Section 11, the term of the condominium corporation shall be conterminous with the duration of the condominium project, the provisions of the corporation law of the contrary notwithstanding. Under with the Section 14, the condominium corporation may also be dissolved by the affirmative vote of all the stockholders or members thereof at a general or special meeting duly called for the purpose, provided that all the requirements of Section 62 of the Corporation Law are complied with. Under with the Section 15, unless otherwise provided for in the Declaration of Restrictions, upon voluntary dissolution of a condominium corporation in accordance with the provision of Section 13 and 14 of this Act, the corporation shall be deemed to hold a power of attorney from all the members or stockholders to sell and dispose of their separate interest in the project, and liquidation for the corporation shall be affected by a sale of the entire project as if the corporation owned the whole thereof, subject to the rights of the corporation and of individual condominium creditors. Under with the Section 16, a condominium corporation shall not during its existence sale, exchange, lease, or otherwise dispose of the common areas owned or held by it in the condominium project unless authorized by the affirmative vote of a simple majority of the registered owners, provided that prior notification to all registered owners are done, and provided further that the condominium corporation may expand or integrate the project with another upon the affirmative vote of the simple majority of the registered owners, subject only to the final approval of Housing and Land Use Regulatory Board as amended by RA number 7899, approved February 23, 1995. Under with the Section 18, upon registration of an instrument conveying a condominium, the registered of deeds shall, upon payment of the proper fees, enter and annotate the conveyance of the certificate of title covering the land included within the project, and the transferee shall be entitled to the issuance of a condominium owner's copy of the pertinent portion of such certificate of title. Said condominium owner's copy need not reproduce the ownership status or other condominium in the project, a copy of the description of land, a brief description of condominium conveyed, name, and personal circumstances of the condominium owners would be sufficient for purposes of the condominium owner's copy of the certificate of title. No conveyance of condominium or part thereof subsequent to the original conveyance thereof from the owner of the project shall be registered unless accompanied by the certificate of the management body of the project that such conveyance in accordance with the provision of the declaration of restriction of such project. Under with the Section 20, an assessment upon any condominium made in accordance with a duly registered declaration of restriction shall be an obligation of the owner thereof at the time the assessment is made. The amount of any such assessment plus any other charges thereon, such as interest, cost including attorney's fee, and penalties as such may be provided for in the declaration of restriction, shall be and become a lien upon the condominium assessed when the management body causes a notice of assessment to be registered with the Register of Deeds of the city or province where the such condominium project is located. The notice shall state the amount of such assessment and such other charges thereon as may be authorized by the declaration of restriction, a description of condominium unit against which same has been assessed, and the name of the registered owner thereof. Such notice shall be signed by an authorized representative of the management body or as otherwise provided in the declaration of restriction. Upon payment of said assessment and charges of the other satisfaction thereof, the management body shall cause to be registered a release of the lien. Such lien shall be superior to all other lien registered subsequent to the registration of the said notice of assessment except real property tax lien, and except that the declaration of the restriction may provide for the subordination thereof to any other liens and encumbrances. Such lien may be enforced in the same manner provided by law for the judicial or extrajudicial foreclosure of mortgage of real property. Unless otherwise provided for in the declaration of restrictions, the management body shall have a power to bid or foreclosure sale. The condominium owners shall have the same right of the redemption as in cases of judicial or extrajudicial foreclosure of mortgages. Under with the Section 22, unless otherwise provided for by the declaration of restrictions, the management body provided for herein may acquire and hold for the benefit of the condominium owners tangible personal property, and may be disposed of the same by sale or otherwise. The beneficial interest in such personal property shall be owned by the condominium owners in the same proportion as the respective interest in the common areas. A transfer of condominium shall transfer to the transferee ownership of the transferor beneficial interest in such personal property. Under with the Section 25, whenever real property has been divided in a condominium, each condominium separately owned shall be separately assessed for purposes of real property taxation and other tax purposes to the owners thereof, and the tax on each such condominium shall constitute a lien solely thereon. And that was the end of my report. I hope you learned something and thank you for listening.